Okay, I'll start, yeah. Hi, good afternoon, everybody. Welcome to Fortis Friday series of webinars. Today's topic is on advanced care planning. Advanced care planning is for everyone, regardless of our age or state of health. Though we cannot predict the future, we can prepare for the unexpected by letting our families know what kind of care we would like to receive should we become very ill one day. Today, Lawyer Berlin she will be focusing on areas like the lasting power of attorney, or LPA for short, the Advanced Medical Directive, or AMD for short, the Advanced Care Planning Workbook, and wills and intestacy. Today, Berlin is our presenter. She is a Senior Associate of Fortis Law Corporation, advocate and solicitor in the Supreme Court of Singapore. Her areas of practice include estate planning, real estate, family law, and elder law. And without further ado, I'll just hand this over on to Berlin. Thank you, Berlin.
Hi everyone, good afternoon. Thank you for joining us this afternoon to learn more about the estate planning. Let me go ahead and share my slides. Okay, so if you have any questions, please feel free to type it in the chat and later on I will answer them. So for today's topic, we'll be talking about LPA, AMD, ACP workbook, and will. The focus will not be on will writing that was covered previously, but I will briefly go through it as well. So just to give you a clear overview, advanced care planning would consist of all these 4 items. These 4 items would be useful for you to have when you're planning what happens in the event that you pass away, in an accident, in anything unexpected, because it will give your surviving loved ones a good idea of how you want your assets to be distributed, how you will want to be cared for in the event that you lose mental capacity. So just as a reminder, I would think that it's a very good exercise to go through to do all these 4 documents. I'll go through page by page later on. Okay, so just a very brief introduction, which Jacqueline has already done. I'm basically an associate of Fortis Law Corporation. Currently, my areas of practice includes estate planning, real estate, family law, and basically elder law as well. So today's topic, we'll talk about LPA, which is called Lasting Power of Attorney, AMD, which is the Advanced Medical Directive, ACP, Advanced Care Planning Workbook, and of course the wills and intestacy. So for lasting power of attorney, as some of you may have heard about it, basically the purpose of this document is in the event that you lose mental capacity, the people that you appoint in your lasting power attorney, who are known as the donees, they will step up and make certain decisions for you on your behalf. Okay, so the LPA is to be done when you still have mental capacity, when you are still in a position to decide who does not, decide who you want to be your donee in the event that you have lost mental capacity. So the second document, and the AMD, is a document for you to decide whether you want to have your life support in the event that you already have low or no chance of recovery. Later on, I'll go into about that. And ACP workbook is also something similar, something related to the LPA and AMD. The ACP workbook allows you to decide how you would like to be cared for in the event that you can no longer express yourself. Unlike the LPA and the AMD, the ACP workbook is not a legal document, but it is still a good document for you to go through and to plan with your loved ones at this point in time when you can make decisions. Last but not least, of course, is the will. The will, as we all know, in the event that you pass away, how would you like your assets to be distributed? So these 4 documents will help you in the event that you lost mental capacity or you're unable to communicate your wishes to your loved ones any longer. These 4 documents will be taken as your wishes and your requests. So I will go in depth into the lasting power of attorney first. Basically, this lasting power of attorney is a document recognized by law. It was actually started sometime in 2014, so it is a fairly new document. It allows you to pre-plan and to think about how you will want to be taken care of in the event that you have lost mental capacity, who you would like to take care of you in the event that you have lost mental capacity, and who do you trust to make certain decisions to decide on who will to sell your property or to hold your property, or whether you would like your bank accounts to be accessed by an individual. So LPA is pretty powerful for the donee because it gives the donee a lot of rights, a lot of ability to touch your assets and to make decisions with regards to your personal welfare. So at the end of the day, the LPA's purpose is to help you as a donor in ensuring that you have a certain quality of life that you're used to leading. Although you have lost mental capacity, your donee will still be able to give you that sort of quality using your monies and your own resources. So there are two types of LPA forms. The first LPA form is called a prescribed form. It is a pretty general form with very few limitations under the Mental Capacity Act. Basically, it gives the donee powers to take your monies and spend it on your behalf. And also it allows the donees to make personal decisions for you. LPA Form 1 is generally used by most people. Alternatively, there's also LPA Form 2. So LPA Form 2 is a bit like a blank sheet of paper where you can write your wishes. The reason why some people use it is maybe they have a lot of assets and they do not want all the assets to be accessible to their donees. So some of the restrictions that we have seen encountered so far include things like maybe I will only want my donee to touch my UOB account for my medical bills. I do not want them to touch my DBS and OCBC accounts. Unless they have run out of money to pay for my medical bills and for my personal care, only then they will be allowed to access my UOB, my OCBC account. So these are the examples for Form 2. Form 2 is quite, let's just say the sky is the limit, of course within the legal framework that we have, but you can customize it to however you like, and things like maybe if you want your children to be able to have access to your monies and to spend it for their education purposes, for their tuition, Form 2 will allow you to do that as well. So Form 2 will also allow you to appoint trust companies to look after your assets and to ensure that your monies are spent properly by these authorized companies. So when you want to think about doing an LPA, what are the things that you have to consider first before coming to us and saying that you want an LPA done? Firstly, you need to know who you would like to be as your donee. Your donee would be the one to be making decisions for you once you have lost mental capacity. So for an LPA form 1, you can choose up to 2 donees and 1 replacement donee. So this is to say there will be up to 3 donees. The first 2 donees, they can either act jointly or severally. Jointly means both donees must come together, have come to a decision before any decisions can be made. But if you allow them to act severally, means as long as one donee is around, then they can act on their own accord. So up to 2 donees, if the 2 donees are not available, as in maybe one of them is not around or lost mental capacity for whatever reason, or just do not want to act, the donee has to renounce his rights as a donee. Then thereafter, the replacement donee will step into the place of the donee who has renounced his rights to act for you as a donee. So the donees have to be above 21 years old. So for those with children below 21 years old, unfortunately, they cannot be donees yet until they turn 21 years old. So, the other point is that they cannot be a bankrupt. So the next question will be, what happens in the event that a donee becomes a bankrupt after acting for you? So at a point in time, if the donee becomes a bankrupt, after that, he or she will not be able to touch monies thereafter. So basically, once your donee is a bankrupt, in order to protect your monies, in order to safeguard your interests, that donee is not allowed to have access to your properties and affairs. However, the donee will still be able to be in charge of your personal welfare. So in that case, if you only have one donee, what happens is that someone else will need to go to the court and make the application to do so, to help this donor to release the monies for themselves. Okay. So the powers granted to the donees, regarding the personal welfare, these are the powers which the donees can do. Firstly, decide on your lifestyle, decide on your living arrangement, and decide on your health care. So to put it To put it simply, basically your donee can decide on your day-to-day care and how you are going to be taken care of, whether they're going to hire a medical helper to help you on your day-to-day, or whether they would like to have a maid to assist you. So the other part will be your healthcare. There are things like clinical trials. If your doctor comes and tell you that, hey, there's this new clinical trial, do you like to try it for your donor? Your donee can also make the decision to go ahead and try it or not to go ahead and try it. Okay. So the other part of the powers granted the donee would be the properties and affairs. So the properties and affairs would simply mean the assets belonging to the donor. So for properties and assets, in the LPA Form 1, you are allowed to restrict the sale of your residential property if you do not want your donee to sell it. So what this means is, in the event that you have lost mental capacity, if you restrict the sale of your property in the LPA Form 1, your donee can look after you, can use your money in your bank account, but they cannot sell your residential property for whatever reason. If they want to sell a residential property, they would have to go to court and seek court approval before they sell the property. This will protect you so that your residential property, if you want to pass it down for your future generation, you can always restrict it in your LPA. So apart from properties and assets, the other things like your bank account, your insurance policy, monies. So in your LPA Form 1, you can also make the decision as to whether you would allow your donee to spend all your monies only on you, or whether your donee can decide who to spend the money on, basically only on yourself or also to give to other people, your loved ones, maybe your children or your relatives. So this is a decision which you can decide when you're filling out your LPA form. Okay. So when you do your LPA, don't worry that whether your donee will take advantage of you and whether they will take money to your bank account without your knowledge. At any point in time, if you still have mental capacity, if you do not lose mental capacity, your donee cannot make decisions on your behalf. Okay, unless your donee has reasonable grounds to believe that you do not have mental capacity any longer, only then they can step in and assist you in making decisions. However, just to let you understand a bit better, for places like organizations like banks, like insurance companies, usually the donee cannot just walk in with the LPA and with their identity card and withdraw money from your account. That is not possible. Usually these institutions will ask for things like your medical memo from the doctor's memo to certify that you have lost mental capacity. And even some other institutions, bank institutions, they may ask for even more documents, depending on which institutions you are visiting. So these are the things that the donee cannot do for you. So they cannot do things like execute a new will for you. They cannot help you decide that it's time for you to get a divorce from your spouse. They cannot change your gender or religion. They also cannot change your nominations for insurance or CPF nomination. So your donee's responsibility is only to ensure that decisions made are made in your best interest. They cannot make optional decisions like aesthetic procedure, CPF nomination. All this cannot be done. If you do not have a will, if you do not have a CPF nomination at a point where you have lost mental capacity, then so be it. That will be what happens after you pass away. Your assets will be distributed as though you do not have a will. So now, who should do an LPA? So LPAs, apart from Singaporeans, for Singapore citizens, the other people who should do LPA would definitely be foreigners and PRs with assets in Singapore. This will ensure that your assets do not get frozen in the event that you have lost mental capacity, and that you will know that someone would be assisting you in paying your medical bills, paying whatever bills that needs to be paid using your monies in the event that your caregiver does not have the finances to pay for you. Okay. So I will now move on to the next point, which is the Advanced Medical Directive. The Advanced Medical Directive is actually a very simple, straightforward document that is used by certified by doctors. So it's basically just a one-page document, and that the doctor will certify at this point in time if you would like to be removed of any life-sustaining treatment in the event that you become terminally ill or unconscious. So this is totally your choice, whether you want to do it. It is best to get it done as soon as possible, so that in the event that you have lost mental capacity and you cannot express your wishes anymore, the doctor would have a copy of your AMD and they would know that that is your wishes and you do not wish to prolong your suffering any longer. Just to take note that this AMD is different from the LPA to the extent that the LPA does not allow your donee to decide whether you should be removed of life-sustaining treatment. So you are the only one who is able to decide whether you should be removed from this life-sustaining treatment via this AMD. Okay, so I move on to this Advanced Care Planning Workbook. This Advanced Care Planning Workbook is basically a non-legal document that it allows you to think about certain questions when you're planning your future in the event that you have maybe a long-term illness that you may not be able to express your wishes in future. So this Advanced Care Planning Workbook gives you a guide. It is a thought process that lets you decide what kind of treatment you would like, what kind of caregiving you would like. So I will just share how the Advanced Care Planning Workbook looks like, and maybe you. Okay, sorry, I'm having. I'll share it later at the end of this talk. I'll move on first. Okay, so this Advanced Care Planning Workbook, basically what it has is there are questions for you to think about. Things like in the event that you are about to reach your end stage in your life, what kind of treatment would you like? Would you like a lot of friends to gather around your bed and talk to you and spend time with you, or do you prefer to be alone? What are your favorite food, favorite hobbies? Basically, it really lets you sit down, think, and consider what you would like in the event that you are about to pass away or to make your life more comfortable. So this workbook gives your loved ones, your caregivers, a very, very good understanding of how you would like to be treated at that stage. So I would suggest for everyone to go through the workbook, look at it, and at least answer the questions as simple as possible, but it will give your loved ones a very, very good guide on what you would like. So the last topic that we will be talking about, of course, is the will and intestacy. For everyone who has a will, it has its pros and cons, and whether if you don't have a will, it will fall under intestacy. So briefly, we will go through what a will is, but like I mentioned, this topic was earlier discussed in much depth, so I will not spend too much time into it. Okay, so basically the will allows you to decide how you would like your assets to be distributed after you pass away. This is a legal document. It is recognized by court. Okay, so why is a will important? It basically allows you to appoint executors. That means who are the people authorized to touch your monies and do the distribution of your assets, and also to determine whether there's a guardian for your minor children. Who would you like to take care of the children in the event that both you and your spouse pass away together? So lastly, it also allows you to decide your funeral arrangements. But just to put a word of caution here, regarding your funeral arrangements, this is not legally binding on the beneficiaries or the executor. The simple reason is that sometimes some people pass away so suddenly that funeral arrangements have to be made immediately. At that point, your loved ones may not know that you actually have a will and have specified funeral arrangements. So there are situations where they have already done the funeral rites, funeral rituals of maybe a Christian funeral. And then after that, when they open the will, they realize that, oh, actually the deceased just wanted a very simple Taoist funeral. So this is not legally binding for practical reasons. Apart from that, other things such as who your beneficiaries are, who your executors are, your guardians are, those are legally binding. Okay. So in your will, what kind of assets can you give? You can give both movable property and immovable property. Immovable property would be things like your condominium, your landed property, your HDB. All these are under immovable property. Movable property will be things with like your bank accounts, your cash card, anything which is of value to you. So it even includes things like your mobile phone, your laptop, things of value to you and is movable property. So these can be distributed under the will as well. Okay, yeah, sorry. This is the immovable property which I just mentioned, basically any types of property. So when you are distributing immovable property in your will, you have to keep in mind that if the property is co-owned, if it's owned by more than one person, it may not be able to be distributed under the will. What this means is that there are two ways of owning a property. One way is through joint tenancy, another way is through tenancy in common. So if your property is owned as a joint tenant, what happens is that under the law of survivorship, the surviving person would be the one who owns the whole property at the end of the day. However, if you're owning the property as a tenancy in common, that means you own maybe 30% of the property. If that is reflected in your title deed, then you are allowed to distribute that 30% to whoever you want inside your will. So if you're not sure, please check your title deed to see whether you're owning the property as a joint tenant or a tenant in common, because the legal implications are very different. The other type of property will be the movable property. For bank accounts similar to immovable property, what happens is that if you have a joint bank account with someone else, when you pass away, the other person will be the sole owner of the bank account. Okay, so unless this is disputed, the bank account will be owned by the surviving person. So the second part is regarding shares and investments. This you can put inside your will, no problem. Jewelry, clothes, furniture, anything of value to you, it can all be placed inside your will. Okay, this is assets which cannot be given under the will would be your insurance policies with nomination and CPF, joint ownership properties and joint accounts. For insurance policies with nomination, the monies will automatically go to the nominated parties. CPF as well, the same thing. If there's nomination, it will automatically be given to the nominated parties. If there is no nomination, it will follow the Intestate Succession Act. I will go into the Intestate Succession Act later on, but just to let you know is that CPF monies, they'll follow either intestate or the nomination. This will be done by the government, it will be distributed by the government, and it will not form part of your assets under your will. So now the question is, what if you pass away without the will? This would be the distribution in accordance with the Intestate Succession Act. Basically, the left column shows what happens if the people on the left are still alive, who will be getting your monies. So if you only have a spouse, your spouse will be getting 100% of your estate. If you only have spouse and children, and maybe 2 children, your spouse will get 50%, your 2 children will have to share the 50%. If you only have spouse and parents, then your spouse will get 50%, your parents, if 2 of them are alive, they both would have to share the 50%. And then it goes on to see who is still around and who will be able to benefit. And of course, if you do not have any next of kin or relatives left, at the end of the day, nobody benefits except the government. So at the end of the day, doing a will would ensure that your loved one's future is secured. You know where the monies are going. Your loved one know that they will not be left stranded as well, especially for younger children and those who are still studying. So at the end, doing a will is very important for you to have a peace of mind. At the same time, to assure your next generation that there has been plans in the event that anything unexpected happens. So just give me a minute. I will try and show you the workbook. Okay, so I'm done with the wills. I will just go back and show you how the workbook looks like to let you have a better understanding of it. So basically, this is the workbook. It is called My Care Wishes. It is basically the advanced care planning workbook. So in this workbook, it allows you to answer questions like, what is living? What does living mean to you? How does it give your life? What gives your life purpose? Things like your relationship with your loved ones. What do you like to do? Do you like to meet your friends? What kind of hobbies do you have? So later on in the workbook, it also goes into questions like, if you have a serious illness, what are your fears? What are your worries? And also, if you become very sick, what would you like to do, and the people you like to be by your side? Like, how is your relationship with your friends, your pets, or the kind of activities you would like to do? Whether you would like to be in your home house, in your own room, or maybe in the hospital, and under the doctor's watchful eye. So this workbook is very useful in allowing you to think about things that you do not necessarily consider in your day-to-day. Okay. So this workbook also allows you to plan on the important things that will matter to you, how are they important, and what you would like to maybe tell them or maybe let them know before you pass away. So I would suggest that this people who are doing the estate planning should not leave out this workbook as well, because I know that most of my friends and their parents, when they do their will and their LPA, they don't usually consider looking at this workbook, which I feel is very important. So I will just go back to my slides. Okay, so I'm done with the presentation. So just to share with you a little bit about our firm is that we do have other services as well. If you would require any services under these areas, please feel free to contact us. And these are our contact details. So if you have any questions, maybe you can drop in the message in the chat and I will start answering them.
Thanks, Berlin. Just a question actually that was asked by somebody. In this instance of the advanced care planning workbook, is there like a central depository that this workbook is kept for the loved ones to know the various aspects of this workbook that has been done? Is there like somewhere that it can be kept? Or it's just personally that a person has to be responsible for sharing with their loved ones that this has been done?
Yeah, this one there's no depository because it is it's a bit like a diary. It has no legal effect, but it's just something, my wishes lah. So there is no specific place where it can be kept, but I would strongly suggest to keep it with all your important documents like your will, your credit, your maybe bank account bills, so that when your loved ones search for these documents, they can be easily retrieved.
Okay. So I think it's really important, as you mentioned earlier, right, that this whole process really entails a series of conversations with our loved ones to ensure that they know that a will, for example, has been done, a LPA has been done, right? So at least when something happens, our loved ones will know where to locate them and what has been done, right?
Yeah.
Okay. And I was just actually also, someone had asked me this question some time ago as well about keeping the wills, because oftentimes we actually have done a will and then, we kind of put it somewhere and we forget all about it and no one really knows where it's kept. Is that like a wills registry that we should be looking at as well?
Okay, yeah, regarding the will registry, we do have a will registry in Singapore, but just to take note, the will registry only contains information regarding your will. So it's things like where your will was done, who drew up your will for you, where was it last kept, and the date of the will. But the original will document would be kept by you at the end of the day. And you would still need the original will in the event of your loved ones applying for the grant of probate.
All right. Thank you, Berlin. I think there's some questions that have come through as well.
Yeah, okay, so Alice has asked this question where there is only spouse and parents, and both parties will get 50% each of the assets. This parent is the deceased as parent or the spouse parents. This, okay, the parent that is referred to in that slide. Yeah, okay, so that will be paragraph 3 in this slide. So this parent would refer to the deceased parents. Okay, because this table is only for the deceased, the relationship to the deceased. So the spouse and parents would be the deceased parents. Okay. So the next question is from Jolene on whether you can do the advanced care planning workbook individually, or do they need a professional medical care person to assist? This advanced care workbook, you can do it at your own time. It does not require any medical professional to assist. But if you would like some services to assist you in planning this, in filling up this workbook, there is also LifePoint, which will assist people to go through the workbook together and to give them certain ideas on how they can fill out the workbook and basically walk them through this whole process. So do we have any other questions?
Yeah, any other questions from anybody?
Okay, there's a question. In scenario where spouse and children each get 50%, if children are minors, who can access to the fund? Okay, so I guess this is a scenario where the children are, this is a scenario where the deceased passed away intestate, which means that there is no will that has been done. In such a circumstance, firstly, when the deceased assets are distributed, the first thing that must be done is to get a grant of letter administration from the court. So when you get this grant of letter administration from the court requires 2 adults to act as the administrator for the deceased estate. So in that case, these 2 adults will be acting as the people who are in charge of the funds of the children. Usually in such cases, the people related to the spouse, like maybe the spouse sister, spouse brother, they will be the one who will be taking care of the monies on behalf of the children. Alternatively, they would also be able to transfer the monies to the guardian if it's not the same person who will be able to access to the funds. Okay, so Fong Yi Yuan asked, where can we obtain this workbook? Okay, this workbook, you can download it online. It is called the Advanced Care Planning Workbook. Just do a quick Google search, you will be able to find it. Okay, so the next question is from Casey. If a private property is being held in trust by a trustee for a minor, what happens if the trustee passes away? Okay, when the trustee passes away, we need to see whether the trustee, firstly, whether there is a replacement trustee, or whether the trustee themselves, they have their own will, or whether they have their last, basically it's just their own will. So at the end of the day, if the trustee passes away, someone else can step up and be a trustee in the event that there is no replacement trustee inside the will document. Okay. So usually when we do drafting of will, we always encourage the testator, the person who is writing the will, to make provisions for situations such as, if the first executor passes away, do we have a replacement executor? What happens if your beneficiary passes away? We usually add these type of clauses, and we usually have this type of discussions with our clients so that we have a clearer picture of the unfortunate scenario where more than just the trustee passes away, but also their executor and their beneficiaries. Okay, the next question that I have is, if children and parents, what is the percentage of distribution? I believe what this question means is that if only the children and parents is around, what is the percentage of the distribution? Okay, for this case, right, firstly, you have to see whether the spouse is still around. If the spouse is not around, then the children will get the 100% distributed. Only if the children are not around, then the parents will get a share of it. Okay, there's a question that said that if you are estranged from your siblings, how do you ensure that your assets are not passed back to all those people? Can you state in your will that by no means any of your siblings inherit anything? Yes, you can. So this is why you do a will, to ensure that your last wishes are being respected. So if you do not want your siblings to get anything, you write your will and say that your beneficiary A is your friend, beneficiary B is your cousin-in-law, and then just to protect yourself or to be extra kiasu, you also can state a clause to say that at any point in time, if any of my beneficiaries pass away, the sum of money that he or she would have received had he or she survived me would be going to this other person. So at no point in time should any of my siblings, then you put the name A, B, C, D, would inherit anything from me. You can do that as well. Okay, the next question I have from Margaret is whether we can draft our own will. Yes, of course, most certainly you can draft your own will, but at the end of the day, you have to ensure that certain legal requirements are met before your will is being recognized. Okay, so if you're not sure, I will always encourage you guys to come to us or any law firm, any lawyer, to get your will drafted. It's always safer and it gives you a peace of mind that your will is drafted in accordance to the law. Because if it's not drafted in accordance to the law, it can be challenged. It will not be accepted by the court, and that means that your will not be taken into consideration at all in the event that you pass away. Okay. So Jolene has asked this question of whether a joint account need to be mentioned in the will. No, a joint account does not need to be mentioned in the will because, like I mentioned earlier on, for things like joint bank account, in the event of one person passing away, the other person would be the sole owner of the bank account. Okay. The other thing I would like to add on is also with regards to your will, when you are drafting your will, there is no need to mention all your assets in the will. Unless you have a specific gift to give a specific person, like for example, I want my HDB to be given to my son. Unless that is the case, if all your assets you want to distribute it equally to maybe your 5 children, you can just say that I want to distribute all my assets after minusing all my funeral expenses, testamentary expenses, whatever expenses, and also all my debts. I would like to distribute it to my 5 children, A, B, C, D, E. You do not need to write what your assets are. This is also for convenience to ensure that at any point in time, if you have new assets, then you do not need to keep amending your will and keep doing the new will. Okay. So Margaret has asked a question on the cost to draft a will. Okay, actually for today, all our participants, there is this special package which I did not mention earlier on. So basically, this special offer is by our sister company, which is FortisWills. There is a package for will lasting power attorney, advanced care planning workbook, and advanced medical directive. So if you would like to know more, please contact them either by email or by the phone number given below, and they will make the arrangements and they'll share you more about this promotion. Okay. So do we have any other questions? Okay, someone has asked the maximum number of times you can change your will and how often should one do it. Okay, you can change your will as many times as you want, as long as it is indicated clearly in your new will that you are no longer using your old will. There is no maximum number of times that you can change your will. The second question is whether how often one should do it. Okay, basically your will, unless you have a change in distribution, unless you have a new family member, unless you want to give something to a beneficiary who was previously not in your previous will, then you should change your will. If there's no change in your instructions, there is no point in changing your will. Let's put it this way. So with regards to changing will, usually maybe if you have a new child and you want to include this new child into your will, then it will make sense to do your new will. Okay. Or maybe, for example, you strike lottery and then you suddenly have $1 million and you decide that, I want to give this $1 million to my friend, and my friend was initially not in my will. So I'll do a new will just to include his or her name and also to include the new gift that I intend to give her. The next question is, if you have assets overseas, can you include it in your will? Okay, in your Singapore will, we do not recommend clients to have a will that encompasses your assets all over the world. The simple reason is because the laws in different parts of the world is very different. We cannot advise you on the laws of other countries apart from Singapore. That's the first reason. The second reason is, even if the other countries accept the will done in Singapore, what happens is that you only have one original will, and the court in the other country will most likely request to see the original will before they can grant you the grant of probate. Okay, so in that case, we do not recommend that you have one will for all the countries. Instead, if you have assets in Singapore, in China, in UK, you should do 3 separate wills so that it can be executed at the same time upon your demise. Okay. So Jolene has asked a question regarding joint account. She asked that if you mention the joint account, you don't need to mention in the will. What if the intention is not for the surviving partners to inherit the money in the joint account? Okay, if that is the case, I would suggest to take out all the money and put it in your sole account. Because what happens is there is understanding that joint account is monies for the 2 parties that is put either together by the both parties or is meant for the surviving party. So if the intention is not for the surviving partner to inherit the money, it is best that you remove that money from your joint account. Because even if you say that, it will still result in a possible dispute of the monies after you have passed away. So let's assume that you are person A, okay? So if person A says in her will that this joint account, Citibank Gold Membership Joint Account, is meant for my children C and D. But the joint account is owned by person A and person B. So under the law, when you pass away, the joint account would be owned by person B entirely, and it will not be given to person C and D. So what person C and D will do is that they will go to court and they will contest the monies in the account, saying that, hey, actually these monies are for me. So the court will look at things like, who put in the monies in this bank account? Was it only A, the one putting the monies in the bank account, or did B also contribute to the account? If B also contributed to the account, then we cannot say that the monies was A's monies and that it was distributed for the children C and D. Okay, so Jolene has clarified saying that the money belongs to the old folks using children name to open a joint account. Okay, I'm not very sure. So does this mean that, like, you open the joint account with your name and your child's name, but you do not have intentions of giving the monies to the children? Okay. So Jolene, maybe you can take it offline. You can drop us an email and then maybe I can understand your question better and advise you accordingly. So the next question I have is, we can unseal the envelope of the will without losing the will's efficiency, correct? Yes, having a will, the envelope of the will does not matter at all whether the envelope is sealed or not. The will is still useful, it's still effective. And this has a question of what happened to my 70% equity in my company if I die without the will. I am assuming that you are the 70% shareholder of a company. So if you pass away without the will, your shares will be divided in accordance with the Intestate Succession Act, which I went through with you earlier on. Which is this. All your assets, regardless of what assets you have, shareholding, shares, properties, it will all be distributed in this manner. Okay. So I think that's all the questions we have. Jacqueline?
Yep. Yep, thanks so much. And I think that the, thanks Berlin, I think it was very well done, very done at a very, very good pace, very good information as well, thank you. And as for the bundle promotion, I think all of you would have received an email by now detailing the details of the promotion of the bundle. So do take advantage of this bundle if you want, because you really have up to 1 year to decide what to do. But do get in touch also with our FortisWills, our sister company, and to ask questions, whatever questions you may have. So if you want the bundle, the whole bundle is there. If not, there are also special prices for each of the components as well. So thank you everybody for your time. Thanks Berlin. And I wish you all, we wish you all actually a wonderful weekend and a safe weekend as well. Thank you so much. Thank you.
Thank you.
Bye.
Bye.